Welcome to the Explainer. If you're prepping for the bar, you absolutely have to master Section 31A of the Federal Court of Australia Act. This is the power of summary judgment, a seriously critical tool for ending a case early. And today, we're going to break it all down for you.
So let's just dive right in by asking a question that really gets to the heart of court strategy. How do you deal with a case that, let's be honest, has no real merit? Or, on the flip side, how do you defend yourself when someone's trying to get your case tossed out before it even gets started? Well, this is exactly where summary judgment comes into play.
You know, to really understand why the current rules are such a big deal, we've got to rewind the clock a bit. Before 2005, trying to get a case dismissed early, it was incredibly difficult, and that's because the court set this extremely high bar. Right, so this was the standard. The magic words were manifestly groundless or clearly untenable, and this came from huge landmark cases like General Steel Industries. What that meant in the real world was that courts were super cautious. They would only throw out the most hopeless of cases. I mean, the ones that were just absolutely without a doubt doomed to fail from the get-go.
And then, bam! 2005 rolls around and Parliament completely changes the game. That old manifestly groundless test from General Steel, gone. In its place, under the new Section 31A, we get a whole new standard, no reasonable prospect of success. And here's the real kicker, spelled out right there in subsection 3. The case no longer has to be hopeless or bound to fail. This was a huge, deliberate move to lower that bar.
So let's take a closer look at this tool Parliament created. We're talking about Section 31A of the Federal Court of Australia Act.
Okay, so the whole point of Section 31A, which kicked in on December 1st, 2005, was to, and I'm quoting the minister here, strengthen the powers of the courts to deal with unmeritorious matters. Basically, it was designed to give the federal courts more muscle to get rid of cases that were just going nowhere.
Now, for your exams, you absolutely have to know how these subsections fit together. So remember, Section 31A, subsection 1, S31A1, that's for the prosecutor, when a defense has no reasonable prospect. Section 31A2 is for the defender, when the prosecution has no reasonable prospect. And the most important bit, Section 31A3. That's the part that says loud and clear that the bar has been lowered. It's the legislative proof that hopeless is not the test anymore.
And just a couple of quick but vital details to file away. Section 31A4 just confirms this power is an extra tool in the court's toolkit. It doesn't replace other powers like striking out pleadings. And very importantly, Section 31A5 makes it crystal clear. This is for civil matters only. It does not, I repeat, does not apply to criminal proceedings.
Okay, now we get to the core of it, the phrase you're going to be arguing about in court. What does no reasonable prospect of success actually mean in practice? How have the judges taken this new power and run with it?
The key authority, the one you absolutely must know, is Spencer v. Commonwealth. The High Court stepped in here and gave us some real guidance. They said the test requires a practical judgment of the whole case. The chance of success can't just be some theoretical, flimsy argument. It has to be, and this is the phrase to remember, real and not fanciful. That should be front and center in your mind.
And this is brilliant. The High Court in Spencer also issued a warning. They basically said, hey, let's avoid creating a lexicon of words to replace the actual test. Your job isn't to ask if a case is frivolous or untenable. Your job is to apply the words of the statute. The power should only be used if the court is satisfied there is, quite simply, no reasonable prospect of success.
Okay, let's get practical. Knowing the law is one thing. Applying it is a whole other ballgame. Let's look at how this actually plays out in court, because this is exactly what you need to know when you're on your feet either making or defending one of these applications.
When you're in court, you have to remember these 4 things. First, the onus is on you, the applicant, and it is a heavy one. Second, the power is discretionary. The judge can say no. Third, courts are cautious. Why? Because we all know that sometimes cases that look weak on paper can end up winning a trial. And finally, know the difference between fact and law. A genuine dispute over facts makes getting summary judgment pretty unlikely, but an unanswerable point of law? Well, that's prime territory for a Section 31A application.
So, when are you most likely to actually win one of these? Here's the playbook. Your application is going to be strongest when the other side's case is built on facts that are just, well, fanciful, implausible, or flat out contradicted by the documents. The other main path to victory is showing there's a fatal point of law, a kind of legal checkmate that means the case is doomed no matter what the facts turn out to be.
All right, let's boil all this down. We've gone through the history, the law, and the practice. Now for the essential points you need to have locked away, not just for your exams, but more importantly, for your entire career at the bar.
Look, at the end of the day, you have to remember that Section 31A is all about balancing court efficiency with the right to justice. Parliament lowered the bar to clear out unsustainable cases, creating that no reasonable prospect of success test, which was then clarified in Spencer. And if you're the one bringing the application, the onus is on you. It's a powerful tool for sure, but it's one the courts use with a great deal of caution.
And that leaves us with a final thought. A question that really gets to the very core of your role as an advocate. See, Section 31A isn't just some dry procedural rule. It's a powerful weapon that requires careful, ethical judgment. It forces you, as a future officer of the court, to constantly weigh these competing principles. The need for efficiency on one hand, and the fundamental right of every single litigant to have their day in court on the other.